Hello and welcome to another episode of Pakistonomy. My name is Uzair, and joining me today is my dear friend and colleague Adnan Ansari. Adnan has been on the podcast before. He's Associate Vice President at the Asia Group, an organization I also work with. You saw Ashok Malik a few weeks ago join the conversation, talk about Modi's India visit. And in the weeks since we had that conversation, there has been a lot of movement on a digital data protection bill in India in terms of protecting citizens' data. There's a whole background to it regarding privacy, big tech. There's a lot of moving pieces over there and some industry pushback as well. And now it seems that in the upcoming monsoon session of the Indian Parliament, that legislation is going to at least move ahead and be debated in Parliament as well. Adnan is somebody who follows India's technology sector very closely. So I figured that we change things up a bit and talk about this very important piece of legislation on two major fronts. One, of course, India is one of the largest internet markets in the world. So a big piece of legislation like the one we're going to be talking about today will impact not only internet users in India and large businesses, but also startups. We'll talk to Adnan about this as well. And the second big reason, of course, is that when a big market like the European Union with GDPR or California with its laws or India with its laws moves forward, other countries also take note and take inspiration from that piece of legislation. In fact, Adnan and I, in our work together over the years, have seen so many instances where European pieces of legislation or policy are copy pasted into initial drafts that then require feedback and tweaks. So that's just how the policy framework globally works. So it's an important conversation. I hope you all enjoy it. So Adnan, first of all, welcome to Pakistonomy and glad to have you on again.
Thank you, sir. It's a pleasure to be here.
So let's begin, Adnan. Help the audience understand, right? Like you and I, you more than I, follow this sort of drafts, comments, different conversations in Delhi about what's going on. But give a 101 about where is this legislation coming from and what's the background that we all should be on the same page about in terms of the what is driving this agenda in the Lok Sabha moving forward.
Sure, sir. So, first of all, before I begin, there are just a couple of things that I want to highlight. One, uh, really, this bill has undergone many changes, and there's a lot that uh, there's a lot that has been written about the bill by critics, by people who support it. So, the key thing to note is that in no way that this is a perfect law. In no way what I will say is gospel. This is just my personal view as I have followed this draft very closely right from the point of when the first committee was formed on to draft this bill, the Justice Sri Krishna committee, and in fact even before that. So let me take a step back. Firstly, let me try and put forth a notion which is talked about quite a lot in India's technology policy domain. That if you look at technology policy legislation, and what technology means. There's a joke that goes around which says that technology for the US is about innovation, technology for Europe is about regulation, and technology for India is about development. So it's it's a very profound statement. While I've heard it as a joke, if you actually look at and that it sort of translates into how policies are formulated, because the US does not have a comprehensive privacy law. There isn't even a talk about it because the US, like true to its laissez-faire economy, it sort of looked at the private sector to sort of come up with almost principles to regulate themselves. And then it's sort of the overarching constitution and the overarching laws of the US taken to protect the users from harms, etc., etc. Whereas the
And
European Union, if
just
you
to
see,
interrupt before you go to Europe, there the U.S. one also is different in the sense that there's a section in the law that protects internet companies, which is being debated about on the Hill. But at the state level, also states have a lot of jurisdiction to do things their own way, and California tries to take the lead. But then other states, like we saw recently with Montana trying to ban TikTok, make stupid choices as well. But that
yeah,
state rights issue and states doing their own thing also plays a role in the US debate as well.
Yeah, exactly. I mean, and the whole uh, thing about the federal government really not intervening as much probably as in some of the other jurisdictions. I mean, that's very clear in the US. Whereas in Europe, we all of us are aware about GDPR and what it has done, and that sort of goes back to how privacy is viewed and how government itself is viewed in Europe versus the US. And when we come to India, I mean, the most important thing to note is that India is a developing country. India has a lot of startups, and India has a lot of developmental goals that it wants to achieve. And therefore, this law, coming back to our law where it stands right now, I personally believe the way it has evolved, where a lot of people would tell you that it's a simple law, is probably the right way to go forward, because right, we could not have actually afforded a very comprehensive, a complex law to begin with. I mean, we'll have to learn how to walk before we can run. So that's really just in terms of just laying the context for this law. Now, where does it all come from? So it all started in 2017 when the Supreme Court of India, in a judgment, unanimously recognized the constitutionally protected right to privacy for Indians under Article 21, considering it intrinsic to life and liberty. So that is where it came from. And then the government formed a committee under Justice B.N. Sri Krishna, consisting of experts to address these data privacy concerns. And this committee came up with a report in July of 2018, along with the first draft law in 31st July 2018, if my memory serves me right, around that time that we saw the first draft of the bill. And since then, it has undergone multiple drafts, multiple changes. It was introduced in the Lok Sabha. It was then recommended to a joint parliamentary committee. The joint parliamentary committee came up with a report. Then it was eventually withdrawn. And then finally, in November of 2022, we saw a revised draft, a simpler draft, a 24, 25-page draft. And now we are at a stage where a draft has been approved by the cabinet as the news report, and it is likely to be presented in the parliament. It has been listed in the parliament, the Lok Sabha session for monsoon. So that's really the evolution of and where the law stands right now and where law is right now.
Thank
I'll
you.
stop here.
Yeah,
Yeah,
thank you for that overview, because that's really helpful. And as you were explaining this, given that we have some level of understanding of where this is coming from, right? The Supreme Court's judgment, I think, was very important. I remember this when it came out back in the day, that it was landmark, right? Recognizing the right to privacy, and it jolted a lot of policymakers, it jolted a lot of technology companies in the sense that, wow, the Supreme Court is taking a position that is going to have repercussions, and that's then led to this law years later. And what I also, in that journey of this piece of legislation and the back and forth and the sort of criticisms, comments, etc., two things at least to me stood out, and I would love your quick thoughts on this as well. One, that it was a robust parliamentary process that was followed to begin drafting it, and there was a lot of back and forth internally, and then also with the technology sector and civil society in terms of what was going to be put into this law. That's why it took so long, number one, which was good in a way, right? When you're legislating something as complex as this, you have to have a robust process that gives everybody a chance to sort of voice their views. And then secondly, given, as you said, where India is in its technology journey, this sort of also provides a sort of a direction, a North Star in terms of where legislation and policy will go now that we're 6-7 years later through this hurdle, almost through this hurdle. Would you then agree with my sentiment that the robustness of the process itself gives it a lot of legitimacy moving forward, because we've seen, for example, in a country like Pakistan, these pieces of legislation come out of the blue, they're railroaded through parliament, and then amendments are made. I'm referring to, in this Pakistani instance, the Pakistani Electronic Crimes Act, PICA as we call it over there. And it's been really draconian as a law, but it also did not follow a robust process that gave everybody an input. So I'm at least glad to see this piece of legislation go through the robust parliamentary process in India?
No, certainly. And moreover, Uzair, before I comment on that, I mean, we have to recognize regulating technology is tough. And I don't want to go, I mean, maybe I will quote the old age adage as it goes that regulation is always catching up with innovation. So, but the problem is innovation moves so fast, so fast forward that the technology innovation moves so fast that regulation is always playing catch up. And the main problem over here is, I mean, I want to actually take an example of something that I heard. We were doing some work in crypto, and there was a person that that I personally interacted with, and this person said that the only way that you can stop me from trading in crypto is you come to my house and take my router internet connection away. There is no way that you can regulate me. There is no way that you can stop me. It's a little bit sort of egoistic, but that is where things stand right now when you talk about regulating technology or regulating innovation for that matter. Now, coming to the point of the parliamentary process, yes, the parliamentary process has been followed and there has been a lot of back and forth. And frankly, if you ask me, in the past 4 or 5 years, the number of drafts that we have seen, the number of papers, the number of reports that we have seen, the government has tried to follow a comprehensive process. However, whether or not, I mean, what this legislation will lead to, it will all depend on its implementation and what really lies forth in terms of the timelines that are given to the sector, etc. So, and plus, there are certain clauses which a lot of stakeholders, and especially folks from the civil society, have raised concerns about. Those are legitimate concerns. I will not deny that. But again, in terms of how this regulation has evolved and what draft that currently stands, I do think that this was possibly the best possible outcome that we could have had, given everything that is going on with India's technology sector and the process the government right to follow. I mean, India is a multi-party democracy, and while the current government has a full majority, I mean, it does it has a full majority in the Lok Sabha. It does sort of lean on regional parties to get bills cleared in the Rajya Sabha, which is the upper house of the parliament. So yes, I mean, I personally think that the government has tried to follow a comprehensive process. There have been hiccups in between, but I do think where we stand right now, we stand in a good place right now in terms of the entire process and the outcome of the draft as.
Okay, so thank you for that, Adnan. Now let's go into the legislation, right? Like we have an audience, so let's start with the user side before we go into the company's technology sector, et cetera side. What are some things that you think the average Indian citizen who's on the internet should know, should care about this legislation? How does this, what are some key clauses that you think people should be aware of in terms of this legislation?
So first things first, I mean, first of all, as a user, I do think that the way that users interact with technology companies, with intermediaries, with social media, with e-commerce will change significantly once this law kicks in. So it will be a cultural shift as much as a regulatory shift, so to say. Because, and that primarily comes from that the outset, the bill says that data fiduciaries, and I'll come to the data fiduciaries later because that's how responsibilities on companies have been defined, may process any personal data of an individual for lawful purposes with the consent of such an individual. So consent is the cornerstone. So you will see a lot of consent notices, and the manner and that is, I think that's the first change that you will see. The bill does talk about deemed consent in certain specific situations where the user, which is defined as the data principal, is expected to provide his or her personal data voluntary to the data fiduciary. that is necessarily, and sort of it lays down to judicial powers, employment purposes, public interest, etc., etc. So yeah, I mean, but coming back to the point, I think for the user, consent becomes extremely important. The bill does try to give you the control of the data that you have, of your own data. Secondly, what the bill sort of it does is it sort of places a lot of emphasis on the companies which are defined as data fiduciaries. So data fiduciaries, it's a fiduciary. I mean, this term data fiduciary has always intrigued me. I mean, fiduciary responsibility is usually seen when we are doing banking, when we are doing financial transactions. So the government of India has used this term data fiduciary, which you will not see used anywhere else. So there are a lot of obligations that are placed on the data fiduciaries. On top of that, the government has defined significant data fiduciaries with a threshold who will have even more obligations in terms of the processing of data, the way and all the obligations that they will have to
And
follow.
in layman terms, a data fiduciary is basically an organization or an entity that collects user data and stores it, correct? That's just basically it.
Yeah. So for example, your Facebooks, your Twitters, your Amazons of the world, they will all be defined as data fiduciary. And I know you will ask me this later, but the term significant data fiduciary has been defined purposely so that some companies could even be excluded from some of the additional obligations. And this goes back to my earlier point that the government recognizes that where we are in our technological journey, where our startups lie. So it is important to create that distinction. And that's a very, that's a change that we have seen in later versions of the law, not in the initial version when it first came out, a more comprehensive law. Then really in terms of, I mean, there are clauses related to penalties. There are obligations defined with breaches. I mean, companies could be fined up to 500 crores in terms of, that's the upper limit when a data breach happens. They have to notify the data principals. They have to also notify the data protect. I mean, there's a data protection board that has been formed, which has been given powers to sort of legislate the provisions of this bill. I'm not going to do the technicalities. There are provisions also defined how that data protection board will function. This is a watered down version of the data protection authority that we saw in the earlier drafts of the bill. And that is the overall structure in which this bill sort of tries to legislate the data of Indians, and it does have extraterritorial obligations as well in certain conditions, but by and large, for companies operating in India, this is what they'll have to follow. I think one of the significant changes that we have seen, and some of you must have heard about this, there were provisions related to data localization in the earlier draft. Those have been watered down significantly. From what it seems, the government will allow for cross-border transfer of data, with the exception of some of the blacklisted countries which may be notified. So it's taking that blacklisting approach, and that is something that you will see in the draft, which will potentially be introduced in the parliament in the upcoming session. So that is really just at a very high level in terms of what this bill tries to do. There is, there are really there are duties of data principal also defined. There are some wide-ranging exceptions that have been provided to the government, which I was talking about in terms of the concerns that have been raised by the civil society. I mean, the government is sort of taking a blanket. The government could provide a blanket exemption to its affiliates, the parts of the government, as well as it could define some of the data fiduciaries on which the provisions of the law may not apply. So again, these exemptions are, it will evolve. The other feature of the bill is, and this is also something that that has been criticized by some folks, that it leaves a lot to the delegated legislation. And what that means is that the government will come out with certain rules to regulate some of the aspects of the bill. But again, coming back to my original point, that for a bill like this, as technology is evolving, we could not have had a very rigid framework in place, and this gives the flexibility. But yes, flexibility comes with discretionary power, and discretionary power could be used in either ways as the government desires. So yeah, I mean, there are some concerns, but let's not doubt the intent over here. Let's see how it evolves and see what the government eventually does with those delegated legislations.
Yeah, and I think that last point is super important to just refocus on a bit as well for, the general audience, right? I think this is a trade-off you have to make in policy, particularly policy related to technology and the internet, which is that how narrow can we have a piece or define things in a piece of legislation? And the more narrow you go in that piece of legislation, of course, the more specific it gets, and the more you would say, okay, discretion to the regulator or the authority, name it authority X, has over defining rules and norms. But the more narrow you go, the less that discretion becomes, which then means that if innovation catches up. So, for example, in the last year or so, everything has been about AI. And if this piece of legislation was passed a year ago and was super narrow and did not give that discretion, and AI sort of changed our own understanding of the technology and data protection risks around AI, then that means that you have to go through an entirely new parliamentary process to then legislate the amendments that are needed to then provide that authority. Whereas if you keep a broader spectrum, you give more discretion, but then you also have to have more space related to dealing with innovation, in the sense that the authority can pass or push through new rules and norms that perhaps don't require legislative intervention because the piece of legislation provides you that umbrella framework, right? And I think you would agree that in mainstream conversation, that nuance gets missed because this is about trade-offs. And again, as you said, we will see how this is implemented. But my read of this whole story has been that in a technology sector, more discretion in a way is actually good because the pace of innovation is so fast that you otherwise would spend another 6 years before you figure out a way to legislate AI, essentially.
Yeah. And absolutely, I agree. And in fact, even I think the number of times that the bill says as may be prescribed is around 18 or 19 times it says as may be prescribed. But if you actually read that, and I remember reading this, that it's only in 3 or 4 places that it talks about significant rule making powers. Others are related to notice, technical conditions, registration of consent managers, etc., etc. So frankly, and this does not even stop the government or even the opposition to demand whenever significant changes are to be made, they should be made through a legislative route rather than a delegated legislation route. So that is where I do think that that's an important element to sort of look at this bill. And again, I'm coming back to the point. I mean, we have seen what GDPR did to technology companies in Europe. India actually cannot afford that kind of a disruption. So a very ironclad, comprehensive law, it would have been good on a lot of fronts, but frankly, where we stand right now in our developmental journey, I do think that would have probably done more harm than good. That doesn't mean that it should not evolve. That doesn't mean that as we come to understand the pitfalls of this legislation, the civil society or the opposition or technical experts stop giving inputs to the government and demanding changes in the law. That will have to follow a democratic process, and hopefully we'll be able to follow that democratic process to eventually arrive at a more perfect law. This is not a perfect law, but this is a good law. Yeah.
So let's go into now the technology company side, right? Of course, a lot of concern over the years in terms of what this would include. Most of that concern, in my view, coming from the fact that the compliance burden would just change the economics of how they operate in the market and the liability exposure, et cetera, et cetera. There, of course, now technology companies not all are the same. You hinted to that earlier as well. Big tech is different than small tech. You don't want to, in a piece of legislation like this, you want big tech to have certain sort of accountability mechanisms that they should abide by because of their scale and size, and they shouldn't be able to, in my view at least, complain about compliance burdens because they make a ton of money. Whereas for startups that are, coming out of IITs, etc., trying to do things in interesting stuff and causing disruption in the marketplace, you also don't want onerous legislation and compliance burden because you want them to invest in growth, not on compliance all the time until they reach a certain threshold. So what's the impact of this legislation? Let's start with big tech. What do you see changing for them and how they operate in India, both domestic big tech and also international big tech?
So I think one of the first things that will change is that they will be more answerable and accountable to the Indian government and the Indian public in terms of their data handling practices. I think that is the first change, and that's a mindset that they will have to inculcate. That's a mindset that they will have to work with, because India, for the longest time, and it continues to be one of the largest markets for them. But I do think that they will have to start thinking about India not just as a market that they want to thrive in, but as a country with its own interests, its citizens with its own interests. So I think that's the first thing. And I know I'm making a more political point, but that what this would mean is, this would mean they will have to appoint a data protection officer. They will have to take audits. They will have to do compliance as the law, as the Indian law prescribes, and all the rule making powers that have been provided to the data protection authority, data protection board. They will have to comply with all that. Plus,
the only point, Adnan, you didn't make in that opening was data is the new oil, and then it would be the full-on point of view of the other side of the conversation is the Indian data is for Indians and therefore should be monetized in India.
I mean, see, I would not say data is the new oil, because frankly, oil is a natural resource. It's limited in nature. I've always hated that analogy. I've always seen data. I think data is data, but I think the closest that anything that could come is data is like a form of capital. It's a form of factors of production that in the technology world, that is how I think we should think about it. It sort of leads to creation of infrastructure. It leads to creation of employment and a lot of other things. So that is how we should think about it. And frankly, if we think about data in that paradigm, then we'll have to also think of treating data like that in terms of how its flows should be managed. Its flows really protecting the sovereign's interest. I think the sovereign will come over everything else. And we have seen some of these challenges appearing in Russia, in some of the other African countries where technology companies, foreign technology companies have pulled out. We probably in India will never reach that stage, but that's a valid concern that the government stakeholders, some of them have had. And the experience, I mean, it's also important to point out the experience of the government in dealing with technology companies. I think for the longest time, when notices were sent to some of the technology companies, I mean, this is something that stakeholders say, that these are not my words, but companies would often say that our data resides in XYZ country. So that's why we can't really give you that data in 24 hours or 72 hours. And sometimes these were critical decisions. These were critical situations in which the government really required that data. So, and which is why if you look at, I mean, I know I'm jumping the gun here, but if really in terms of the data transfers, how the government sort of talks about it, it talks about trusted geographies. I mean, that's not the legal language that's being used, but that is how it will operate, that certain trusted geographies. And I would assume that these trusted geographies, as and when they would be defined, or when certain blacklists will be created, the government would take into account that what is the process in terms of accessing data when we require to do so. So I think that's the second change that they will have to do. The third is really in terms of, as I talked about, the consent, the breaches, the reporting mechanisms, and that this is common for domestic and foreign big tech. I think that's a common feature that everybody will have to adhere to. I think when it comes to startups, there is, I would say, there is some sort of room for cautious optimism, because the startups are optimistic, because compliance could create barriers to entry, and high compliance costs could create those barriers to entry, and the government has at least tried that. Seemingly those do not come out in the draft that we last saw, and hopefully that's the draft that we'll see coming to the parliament, because there are provisions, as I said, about significant data fiduciary, in terms of the additional obligations that will be put upon them. Some of these startups may find themselves not defined as a significant data fiduciary. I do think one of the challenges that they might face, and in terms of all the changes that companies advocated for, one of the changes that we have not seen in the last draft, at least, was the definition of children, and how children's data should be regulated. The age of children continues to be 18 in the last draft, as defined in the law. There is some media reportage that the latest draft, which is presented to the parliament, there could be some changes to that definition. There could be some sort of exceptions provided on a case by case basis, and that could be defined in the law. But that is, again, and that's a significant sort of clause, because India is also a very young nation. There are a lot of children who sort of are on the internet, but the government has decided not to follow some of the norms that are there in other countries, where age of children is defined 16 or even lower, for that matter. So that's really the change that you would see in terms of how this bill sort of will get implemented. The other thing which I'm hopeful is that it would prescribe a timeline when that law kicks in, so that the GDPR also had a timeline which sort of gave the companies a buffer, which gave the organizations a buffer to be compliant to the provisions. I'm hoping that when the law is presented in the parliament, it would prescribe that timeline, so that we have some time in terms of getting used to, and companies have some time getting used to the new law as such. So yeah.
And I would even add, it's the timeline, the runway given by that timeline is also important for the government itself, right? Because it needs to set up its own institutional architecture under this legislation to have oversight, right? If you don't have that mechanism, let's say the law is passed tomorrow when we're speaking, and it's implemented tomorrow, neither side has the capability to be in compliance with that law or enforce compliance of that law. At this point in time, and companies and the state is working, but I think that timeline is going to be there for sure. Would you also then agree that for technology companies overall operating in India, this legislation also, much like what happened in Europe, require a mind shift, right? In the sense that they're not used to having to deal with grievances or having to report on breaches a certain way. And of course, the reporting on breaches has its own economic impact on shareholder value and things like that, in terms of, the news cycle and everything related to that. So, would it be fair to say that more so than anything else on the compliance side, the biggest hurdle here, or the biggest challenge here for companies, is going to be, particularly big companies, a mindset shift of now having to comply, which is, we saw this in the banking sector in the United States in 2008 after the crisis. The shift in operating with a heavier mandate of compliance makes you do things a lot differently in terms of your growth strategy. And that's difficult to do. So I would love your thoughts on like that mindset shift that needs to happen as well.
Sure, Uzair. So frankly, I agree that mind shift is extremely important, and that will start to happen, and that's a significant change that you will see. But I also think that mind shift has already started in India, because the regulations, if you look at technology regulations in India, have been in a flux for almost 4 or 5 years. For the internet sector, whether it's related to e-commerce, whether it's related to social media, you have seen companies and the government face to face on a number of issues where where some of the companies have even gone to court against the government on some of the provisions of the law itself. And there are at least a couple of cases that are going on where the technology companies have questioned the legitimacy of the law itself. And then there have been challenges with respect to compliance. There have been challenges with respect to criticism of the business practices of companies by small traders. Then this, I'm talking about e-commerce companies. So this shift is truly and well underway. I do think that the companies recognize this, and frankly, all of us working in the policy space, we have seen that how even the policy teams of these companies have swelled up in the last 4 or 5 years, where there would be 4 or 5 people, but now they have 20, 25 people, just full-time employees. I'm not even talking about external consultants. So I do think that this mind shift where these companies have started to recognize that India as a market will do this. It is in the interest of its own constituents, its citizens, as well as, I mean, India sort of recognizes India is more confident that these companies need Indian market as such, because a lot of the innovation is also happening from India. I mean, there's a term that I heard some time back, that when you use technology, you're not just a consumer, but you're also almost a producer of the technology, because you are sort of giving the companies the data on which innovation happens, on which AI models are changed, on which machine learning algorithms are implemented. So
Even just the millisecond you stop
exactly,
scrolling on your Instagram reels gives enough data back to the Instagram team to know how to tweak its algorithm and what to show you, what not to show you.
exactly. And India, I mean, China is almost closed off for most of these
It's the
companies.
largest market, yeah.
It's the largest market. I mean, the amount of data that Indians are giving is huge, and this is where innovation will happen. And this is why the country is extremely important. So that's where the mind shift is. That's where the mind shift is necessary and truly underway. Going forward, what you'll see is, I mean, I do think that any law, any legislation, there will be challenges, there will be friction to begin with, and we have seen that, frankly, in how India's competition law regime is evolving. While we haven't seen a revised competition law, but in terms of the interpretation of the law as it is changing, you are seeing fines imposed upon companies. So you would see, even when the data protection regime comes into force, there would be challenges for companies, there would be some back and forth, but I think that's just the natural rite of passage that all of us will have to go through and companies will have to go through. Yeah.
And I think that's just broadly like consistent with the what happens when a sector matures, right? Like we've seen this in auto manufacturing, financial services, insurance, wealth management, etc. Like over time, yes, when you're small, people let you get away with a lot of stuff, but then you hit a certain scale, and big tech certainly has hit that scale a few years ago, but it's been such a complex sector to deal with that the legislation is only now coming to bear in markets like India. So it's a sign of the maturity as well. And the old cowboy days are mainly over. Last question on this conversation, Adnan, from you. You mentioned a few times there's a lot else in flux, a lot of other things in the pipeline. What are things you're keeping an eye on in, let's say, the next 6 to 12 months? Of course, India enters an electoral cycle 7, 8 months later. In 2024, essentially, is an election year. So there is a limited time frame of a lot of legislation, regulation going through before the government fully looks at the electoral map. And of course, as you and I know, that timeline also fast tracks certain things as well, because you need to do certain things before you go into election. So what are you keeping an eye out on the policy side that intersects with the technology sector writ large in India?
Sure. So I would cover two main technology shifts, and technology shifts that are happening in India in terms of policy and also in terms of just the sector itself. And both of them are very important. I think in terms of policy, there are broadly four pillars of technology regulation that you will see. One is the Digital Personal Data Protection Bill, which we have spoken about. The other, the government of India is coming up with the Digital India Act, and this is a revision of the IT Act of 2000. You did talk about in the US Section 226, if I recall correctly.
I think Section 230. And let me,
Section 230.
yeah,
Yeah.
the one that gives liability coverage to big tech. Yeah.
Yeah, Section 230, which gives the liability coverage to big tech. So the government, I mean, we had a similar provision in India's IT Act, but that provision also may see a change in the Digital India Act. I think that's the other technological shift, that's the other regulatory shift that you will see, the Digital India Act, and it will define a lot of other things. It will define AI. It will have regulations related to Web3. It will sort of just change the broad contours in which technology companies operate in India. That's the second pillar. The third is the government of India is right now revising the telecom law. I mean, India's telecom law, I mean, it sort of goes back to pre-colonial times. So there is a telecommunications bill that is in the works. So that's the third change that you will see. And again, there's a lot of intersection which you will see with there's a lot of intersection that you will see between these laws. So some of these
just for the audience on
Yeah.
the telecom side, if I may, I just quickly looked it up. It's the Indian Wireless Telegraph Act of 1933, like almost 100 years old. So yes, definitely in need of an update there.
Yeah, and I think the first time it came out, it was an 1885 law, which has undergone
Yep,
a few revisions
since
here and there.
1885. Yep.
1885. So yeah, I mean, about time that we sort of see a revision of that law. So again, there are going to be additional obligations on digital communication services and OTT platforms that you would see as a part of the telecom bill. Then the fourth pillar in terms of the regulation is the digital competition bill, which is again, as I spoke about, I mean, the competition law in India, the interpretation is sort of changing. I mean, there you are seeing fines on certain companies and stuff, but now there would be changes to the act itself. The government, the Ministry of Corporate Affairs, is working on a digital communications bill. Again, there are certain intersections with DIA, and last week there was a media report where the Minister for Corporate Affairs and the Minister for Electronics, they met and they tried to sort of iron out some of these differences and some of these overlaps. So these are the four main laws that are currently being worked upon. There's a fifth, which is not a law, which is the National Cybersecurity Strategy, which the government of India has been working on for quite some time. And the importance of it is again sort of amplified because of a lot of seemingly and allegedly the alleged cybersecurity breaches that have happened on some of the critical infrastructure and some of the other technology platforms and stuff. So these are the five main changes that you are sort of seeing. The other sort of shift that we haven't spoken about, but I'm pretty sure your audience is very much aware of it, is India's digital public infrastructure push. So I know you are a big sort of fan of UPI, but apart from UPI, there are a lot of digital public infrastructure, digital public goods that are being developed. These are related to e-commerce. These are related to education platforms, etc. So again, there's a lot that is happening. I do think some of it will also define some of these provisions, some of these acts that we spoke about. As we have seen, there's a concept of consent managers in the Digital Personal Data Protection Bill, and that sort of gives legitimacy to the whole digital the whole account aggregators and the other sort of DPIs that are coming up, which will handle personal data of Indians. So yeah, I mean, these are the two main things that are happening, which we should be aware of. There is a bunch of other things related to e-commerce laws and e-commerce policy, etc. But I do think for the purpose of this audience, we can just limit it to these two.
No, a lot, as you indicated, and thank you for that overview. A lot going on, and I think for the general audience, right? I think to me, even the conversation, the interesting part here is that the policy making community, both within the government and outside the government, has its hands full, and it's grappling with a lot of things that are now being impacted by a growing technology sector that has reached a certain level of maturity. So now you need to legislate and regulate it in a different way. And a lot of these laws are ancient, as we talked about the Wireless Act since 1885. So they need updating. And I think the second one, which you kind of alluded to also, is that, we often think of government as being this monolith that moves in a certain direction, in a certain tempo, and there's unanimity of views in it. And that's clearly not true. You talked about the Corporate Affairs Ministry and the Ministry of IT hashing things out internally about overlaps, who gets to own what, etc. And I think it's important for people to also understand that that's just how governments operate. It's not just, things don't come out of the blue most of the time. They take a lot of time and years, as this digital protection bill has taken. A lot of internal dynamics come into play. And then, of course, you intersect on the outside with civil society, with business leaders, with investors, etc. So, every once in a while, it's important to have more of a detailed conversation on a piece of legislation that to many may seem it came out of nowhere, but to folks like you spent a lot of years following this, and thank you for educating the audience about that. Since you mentioned the DPI side, I'll just throw that one at you as well. Like, how do you see the evolution of digital public infrastructure in India? I know UPI, I'm a big fan of. I think it's transformative and it's amazing in terms of the market failure it solved for, right? In terms of enabling digital payments for everybody in the country, built on Aadhaar verification and zero balance bank accounts, etc. But now there's talk of like account aggregators, credit profiles, health, mobility, and commerce, ONDC. We've talked, we've seen grow as a big push ahead of elections. Overall, what's your take on, what people should be paying attention to on the DPI agenda push, and how do you see it potentially transforming the country 3 to 5 years down the road?
So, Uzair, UPI is talked about quite a lot, and absolutely agree that UPI is probably the biggest success story of India's DPI story, which has now gone public. I mean, the Prime Minister was in France the other day, and he said that how Indians will be able to use UPI to make payments in and around Eiffel Tower. And yeah, I mean, but
and right before we started our recording, there was an MOU with the Emiratis on something similar as well.
There you go. There you go. So yeah, I mean, UPI is truly going global, and it's a matter of pride for all Indians. But at the same time, UPI is not the only success story from India's DPI. I mean, most of the Indians now use DigiLocker or e-signatures. I mean, again, these are coming from the same vault of India stack and DPIs, and even the most used probably the DPI was the CoWIN platform, which enabled generation of certificates and registration for vaccines during the whole vaccination program for COVID. And India, in fact, made CoWIN open source, and a lot of countries adopted it. So before UPI went global, CoWIN has already gone global, one of India's DPIs. So that's really, I mean, some of this technology shift again is underway, where some of us living in India did not even realize when that happened, but it has made our lives much easier. I mean, I had to pay for 5 repair guys today. I'm just in the process of moving my house, and I just had to transfer even 50 rupees or 70 rupees just in a matter of seconds. I mean, I can't even think of this happening.
You're not going around your home asking, "Bhai sahab, chutta milega ke nahi?"
Exactly. I mean, this is a huge shift, and even carrying around documents. I mean, it was a pretty common thing for people to lose their wallet, and with that, all their driving license, Aadhaar, etc. Everything would go away. But now, I mean, DigiLocker is again a change that all of us use it almost on a day-to-day basis. In terms of its evolution, where it goes, see, I mean, like any technology, I mean, even if the government is backing it, every technology will sort of go its own natural cycle. There will be certain things that will be more successful. There will be certain things that probably might shut down. There'll be certain things, just like any startup. I mean, all startups do not succeed. So right now, e-commerce, ONDC is one of the big things coming out of the government. There are 2 use cases which have found traction. One is on mobility, one is on food delivery. But I do think that there is much more scope in terms of evolution of ONDC. It probably may not replace all of the e-commerce companies that a lot of people would like to talk as political rhetoric. I do think that India has enough people. India is a large enough market for the domestic innovation as well as foreign international companies to coexist. But that's another thing that is happening. Then the government is account aggregator is one thing that we spoke about. You will see as this data protection bill sort of goes forward, you will see more account aggregators coming up, more companies sort of signing up for account aggregators. And then there is open credit enablement network, because that is where the magic would happen. I mean, you have the UPI, which is the railroad that the government has built for money to move on, but now money doesn't really have to move one way. I mean, open credit enablement network will allow credit to become easier for individuals, for MSMEs, and with your account aggregator, almost all these three things will talk to each other. The account aggregator, you would be able to give access to your data to somebody for that data processing to happen. So again, I have a lot of high hopes with this sort of the new trinity that is emerging. So yeah, I mean, that's really the evolution. There are a bunch of other things that the government is trying to do on unified charging interface for electric vehicles. There is also, in fact, I think this week there is a launch for an open source platform for education and skilling. I think it's called Honest. So again, there is a lot happening. You will see some of these innovations scale up. Some of these may even scale down or die, but that's just a natural cycle that any innovation sort of follows.
Yeah, and I think that's an important point, right? And to me, I'm with you. The most exciting among them is how does the infrastructure built on UPI with account aggregators and open credit allow access to credit to grow, right? Because we know very much so from global research, information asymmetries increase the premium, that then increases cost of credit and also puts a lot of people out of the sort of umbrella of access to credit. And societies and economies cannot grow unless access to credit is solved for. And in a large and complex country like India, where the old way of doing business, where traditional banks have for decades failed to solve that problem, technology funded by the state is helping solve that problem. And I think if that scales the way, even half of the scale at which UPI is at right now, it's going to be transformative, right? Because at the individual business level, it'll solve so many problems. Not only economically, I think we also forget over there that because access to credit is such a problem for citizens across the subcontinent, it doesn't mean they don't access credit. They access credit through loan sharks and informal markets, which then has a human trauma associated with it if you fail. We've seen in India and recently this week in Pakistan a crackdown on loan shark apps that have been operating unregulated, and people have been committing suicides because of the harassment that comes with your failure to A, not fully understand what product you're being sold, and B, when you are unable to pay the very high extractive rates of interest, usually as you would call it in the old parlance, people kill themselves because they're unable to pay. And I think that's traumatic, that has impact on society. And so if a state can solve for that access to credit problem, it has a human impact as well. So I'm excited as much as you are on that as well, and hope that it scales. On that note, Adnan, thank you so much for taking out the time, joining us again on Pakistonomy. We'll keep following these developments, and as things move forward on the other pieces of legislation and regulation you highlighted, we'll probably bother you again. But in the meantime, have a good rest of the day.
Thank you. This was really great.